Okay, we're live?
Yes.
Okay.
It may take a moment for audience members to
Sure.
join. We have a few. And here comes one of our staff attorneys.
Kristen.
And we don't technically need either one of them for the administrative items.
Okay.
We could start with the agenda anytime.
Okay.
And I'll mention that I just noticed that I spoke with John Anderson, who's the liaison between the Trust and Estates section of California Lawyers Association, what we used to call TexCom, on our estate planning bills, and he graciously agreed to join us here today.
Okay.
But the estate planning item is the last one on the agenda, so depending on who shows up in the audience, it might make sense to reorder things a little bit once we're done with the admin items, just to accommodate.
Okay. Yeah, we can sort of play it by ear.
All right. Great.
All right. Well, the August meeting of the Law Revision Commission is now in order. Brian, should we take the roll to establish a quorum?
Sure. I will call the roll and just say aye if you're present or here or something. Alphabetically, Commissioner Carrillo.
Present.
Commissioner Carrion, I know, has told me that she will not be present today. Commissioner Cubas.
Present.
Commissioner Hebner.
Present.
Commissioner Jenkins.
Here.
Commissioner King.
Here.
Commissioner McAllister.
Present.
Chairman Simpson.
Here.
So we definitely have a quorum.
We have a quorum. Okay, first item on the agenda is approval of the minutes. Is there a motion to approve the minutes?
So moved.
Okay, David, is there a second? Yeah, Jane?
Yeah.
Okay, it's been moved and seconded. Any comments or questions regarding the minutes?
I'm going to abstain since I wasn't here.
Staff
Okay.
has no proposed changes.
Okay. Okay, let's call the roll to approve the minutes.
Carrillo
Abstains.
He's abstaining.
abstains. QS,
Aye.
Hebner,
Aye.
Jenkins,
Aye.
King,
Aye.
McAllister,
Aye.
Simpson.
Aye. Minutes
And
are approved.
I'm not calling the names of absent members and then
Right.
there are two legislators.
That's fine. Okay, administrative matters. First up is report of the executive director, Brian.
Yes, the only significant item I have to report is that we're back on Zoom. There was a budget trailer bill enacted, and budget bills take effect immediately, and it reauthorized the waiver of certain Open Meeting Act requirements that created problematic obstacles to meeting entirely on Zoom. So once that change was made, this became possible again. And I spoke with the chair, and it was his preference that we hold this meeting electronically on teleconference rather than in person. So here we are. And the trailer bill has a time limit on it. It sunsets on, I believe, June 30 of 2023. So we're good for the rest of the fiscal year. One of the things I wanted to ask about was that when we were thinking we had to go back to in-person meetings with a hybrid component like we did last May, the commission decided to drop half of its scheduled meeting dates to double the interval between meetings to 2 months approximately. And we did that for this meeting, but I don't know if you want to continue to do that for the remainder of this calendar year. And concretely, what that means is that I'm asking about whether or not you want to restore meeting dates on September 22, October 10, or December 15th. December 15th, we retained as a sort of a wobbler, that it was on our calendars and we would use it if we needed it, but we weren't planning necessarily on the meeting. So September 22 and October 10 are the key dates.
What
October 20th.
Yeah, sorry, I made that mistake twice and David corrected me both times. Thank you.
It's my birthday.
Happy birthday. So let's meet on his birthday. Ruben this morning. I don't really have a strong feeling either way. We're all the staff are working on projects that sort of have long runouts where there's lots of staff work and not a huge amount of need for commission involvement and approvals in order to continue to make progress. The only exception to that is that it might be nice to hold a meeting earlier so we could touch base about our new topics and priorities for 2023. We do have 3 new legislative assignments coming. 2 of them are in the form of resolutions, so they will take effect immediately on chaptering. And so the commission might want to touch base and think about how are we going to divide our staff resources next year. Might be helpful to do that before our scheduled November meeting, but even that is not super critical because I don't think realistically we're going to have the resources to jumpstart those studies between October and November.
Well, does it make sense to see what people, well, first of all, see what people's views are, but perhaps do the September 22 meeting and then at that point see what the rest of the calendar year looks like? Whether we need something in November or not?
Well, we've got November. October is
Yeah,
the
oh, sorry, not in October,
But-
sorry.
But the idea, I think, is clear, which is do September and then reassess.
That was sort of my thought, but any other thoughts from commissioners?
I think that makes sense. Obviously, Brian, you and staff would know how productive it would be to add all of the meetings in. So
Right.
whatever's the most
Yeah.
efficient is fine either way. I mean, I don't care, but I think that's a good idea, Commissioner Simpson.
Okay.
So is that the decision?
Why don't we, any objection to doing that? Seeing none, hearing none. Okay, let's recalendar the 22nd and then sort of see where we are for October.
And I'm going to call the roll on this.
Okay,
Carrillo,
Aye.
Cubas,
Aye.
Hubner,
Aye.
Jenkins,
Aye.
King,
he's aye.
McAllister,
Aye.
Simpson.
Aye.
That concludes my executive director's report.
Okay. Next on the is commissioner suggestions. Any members of the commission have thoughts about topics, discussion procedures, anything they want to share? Seeing none, hearing none. Okay. Next on the agenda, election of officers. It is the term of the chair and vice chair ends at the end of this month. So we need to elect a chair and vice chair. So why don't we open nominations for the office of chair? Is there a suggestion, a nomination? I would, if I don't see anybody else, but I would like to nominate Commissioner Carrillo for the office of chair.
Thank you.
Second.
Is there a second?
Second.
Second. Are there any other nominations for chair? Hearing none, seeing none. Now's your chance.
Does this mean I can't move to adopt the minutes anymore?
Maybe not. All right.
Yeah.
So seeing and hearing no other nominations are closed. Brian, do you want to call a roll to?
Well, maybe let's do the VP and I'll call the roll on the slate.
Oh,
if that's
okay,
All right.
sure. Is there a nomination for the office of vice chair?
Commissioner Hubner.
Commissioner Himner?
Mhm.
Okay. Is there a second? I
I'll
was-
second that.
Okay. Been nominated, there's a nomination and a second. Are there any other nominations for the office of vice chair? Seeing none, hearing none. Nominations are closed. Okay. Brian, you want to call the roll for the,
Yeah, so the proposal is David Carrillo as chair, David Hebner as vice chair.
that's correct.
And I'll call the roll. Carrillo,
Aye.
Cubas,
Aye.
Hebner,
Abstain.
okay, Jenkins,
Aye.
King,
Aye.
McAllister,
Aye.
Simpson.
Aye.
Okay,
So Mr. Ebner thinks this is fourth grade and doesn't get to vote for himself.
I've never voted for myself in my life. I'm not starting now.
Ah, well, for those of us who have served in actual elected office, I always voted for myself. So,
all right.
okay, well, congratulations to our new folks. The terms start 1st of September.
Thank you.
And
Thank you.
look forward to working with you all. And the last item under our administrative stuff is use of subcommittees. Brian had a memo.
Yeah, what's the story on that?
Yeah, this is memo 2233.
Yeah.
This came out of a suggestion that was raised in May when we were talking about the proposed new commission studies. Commissioner Cubas asked about whether the commission can properly use subcommittees to work on the commission's study work. And I think with a particular interest in the SCR 92 LEBA, the Equal Rights Amendment project.
Mm.
And so I'm hearing an echo. Is that
I hear that too.
all right? Yeah, not sure. How about people who aren't talking mute? And we unmute ourselves just when it's time to speak, and we'll see how that works. Okay, thank you. The question was whether we use subcommittees and sort of what would be the complications of it. And I noted first place I always go for questions like that is the Commission's Handbook of Practices and Procedures, which is more of a memorialization of prior decisions than anything else. It's also sort of intended as a description of process for people to quickly understand how the Commission works. And there actually was a decision on the use of subcommittees back in 1960. The Commission decided against a proposal to use subcommittees, but it clarified that it was only making a decision with respect to subcommittees that are used to sort of review topics and make initial recommendations to the Commission. I'm not quite sure what other purposes they had in mind, but one example that occurs to me is that we operate as a nominal subcommittee when we don't have a quorum, so that we can still make progress and then come back later and have ratification votes. So that's not the kind of thing we're talking about. I think we're talking more about individual commissioners or a subset of the commission acting to sort of gather information and perhaps make some initial provisional conclusions about studies in order to enhance the efficiency of the commission as a whole by sectioning off some stuff for sort of pre-digestion, I guess, by a subset before it's brought back to the commission with, so it's sort of an extension of the work that the staff does. And so one of the things I emphasized in the memo is that while the commission previously made this decision that they weren't going to use subcommittees in that way, that doesn't bind you. That was just a decision for the commission in 1960 about how they were going to operate. And you're free to change your mind for the commission of 2022. You can do whatever you want with subcommittees. The second question that I looked at was, what are the legal restrictions on the use of subcommittees? And there, the most obvious issue is the Open Meeting Act and whether or not the subcommittees if they were formed, would have to operate in the same way as the full commission with respect to meetings, i.e. Only work in meetings that are noticed and with an agenda that's given out in advance of the meeting, guaranteed right of people to attend, guaranteed right of people to speak and be heard. All of those important values that the Open Meeting Act protects, we would need to know whether they would apply to a subcommittee if it was getting together to work on commission work. And my conclusions were based on the Bagley-Keene Open Meeting Act's definition of state body, because that is the definition that controls the application of the Open Meeting Act. It applies to state bodies. And there are a couple of prongs to the definition in Government Code Section 11121 that are relevant to this and worth looking at. One of the prongs defines state body to include an advisory committee that's created by formal action. If it has 3 or more members, okay? I'm not certain what an advisory committee would mean in this context, but it's worth assuming that it would apply to what we're talking about here, so as not to risk violating Open Meeting Act requirements. The good news is that if we had a subcommittee of 2 people, that wouldn't be a consideration. They would not be subject to the Open Meeting Act. And then the other requirement is a multi-member body that exercises authority delegated to it by another body. Now, key terms here, multi-member. So that means more than one. A one-person subcommittee would not fall within that prong. And then the other key term is that it has to exercise authority that's delegated to it by another body. And the Attorney General opinion I looked at on that suggested to me that they're talking about a body that can act. So for example, they said if there's a subcommittee created to make decisions for a body between meetings, if something comes up that has to be addressed immediately, you might have a subcommittee that's there to deal with urgent needs. And in order to authorize things or bind the body, that's what I think it means when you say delegated authority. It's an exercise of authority, not simply talking or learning things. But again, I'm not sure where the boundaries exactly are. Because if you were talking about a body that has the authority to hold hearings, like we're going to have a meeting where we're going to have these 3 stakeholder groups represented and come in and talk to us about this topic that the commission is studying. I'm not sure if that's exercising authority that's delegated from the commission, because that is one of the commission's principal functions, is to gather this information. But the commission's other principal function is to make decisions based on that information. So I do see that there's a line there that we could use to try and justify, if we want to, arguing that a subcommittee is not subject to the Open Meeting Act. But I just don't know whether we would get pressed on that and how it would come out if we were. So I think the safest course is to conclude that a subcommittee of 1 is the only subcommittee that we can be certain is not subject to Open Meeting Act requirements. And that, we sort of do that in practice already. There are times when the commission will say something like, we approve this recommendation with the understanding that staff's going to make revisions of the type that were directed here, subject to the final approval of the chair. Okay, and in that sense, the commission is delegating to the chair some of its authority that it holds to approve a final recommendation. in final form. They're saying we'll let within the constraints that we just described, we delegate that authority to the chair to act alone. And so, like I said, we do that already. If the commission was interested in tasking individual commissioners with working outside of the ordinary meeting, the regular scheduled meetings, to work with staff and with stakeholders to just hold information gathering meetings. And I sort of think that that's probably the best function, and perhaps what Commissioner Cubis had in mind. If it was just one commissioner, that wouldn't be a problem. It wouldn't be an open meeting governed event. So, for example, talking concretely about this study about the Equal Rights Amendment, there might be groups out there, stakeholder groups, who have opinions and information about what ought to be addressed in that study. And ordinarily, the staff would make inquiries informally on the commission's behalf to learn from those people and to get the information they have, to hear their opinions about how things ought to be. And we would do it without any sort of public openness to it. It would just be a phone call or an in-person meeting or something, or Zoom meeting. And like I said, we've always done that just with the staff. I don't think there's any legal impediment to a single commissioner playing a part in that kind of operation. I think if we had 2 or 3 commissioners doing that, then we start to get onto unclear ground. And I think it would be really burdensome to hold those kinds of informal information gathering meetings as open public meetings. And, you know, the stakeholders might not feel free to speak frankly about their views, you know, in a helpful way. The other more ambitious possible role of a subcommittee, which was mentioned in the 1960 memos that I quoted from, was to sort of delegate to a subcommittee the authority to take the first bite at the apple, with the assumption that their conclusions about the law and policy and the way that the law should be reformed would routinely be ratified by the commission as a whole. So sort of a delegation of trust to a subcommittee to do the commission's regular deliberative process in miniature, with the assumption that they will probably get it right and we'll bring it back, and the commission will routinely say, yep, that makes sense to us. That is the commission's decision. That's what the former executive secretary at the time was sort of counseling against. That they had tried that kind of thing in the past, and he didn't think it worked very well. So I guess that's all the information that I have to offer, and I guess the issue has to do with what is it that you think you would want these subcommittees to do if you want to have them, and then once you have an idea of what you want them to do, then we can think about whether that would be the kind of thing that might trigger the open meeting requirements. Does that make sense?
Yeah, let's see, Victor has his hand up.
And so
Yeah,
And then
I've, you know, as of, you know, I was an elected official for 12 years, and I've used subcommittees, and I'm a little curious about the proposition that we can't have a subcommittee of 2 that could even meet. I don't think that would trigger any sort of open meeting or notice problems. Under Bagley-Keene Act, by definition, 2 people are not a formal, quote, advisory committee of the larger entity that would create a open meeting problem. So I'm familiar with subcommittees of 2. I've used subcommittees of 2 before. And if we were going to get that technical about it, you know, I should never have lunch with David or Rick or anybody, you know, because that'd be 2 of us. I just don't see that 2 would be a problem. So my preference would be that the subcommittees be of 2 people, and that, you know, for the simple purpose that, you know, it's a check and balance. When you have 2 people, you have 2 people are working on the same thing, and you can make sure that the subcommittee is not steering towards some sort of explicit or hidden bias. And then as for the second part, as to whether or not we should presume that their work is accurate and the committee adopted, obviously that's very problematic. I think the subcommittee should be highly advisory and not have any binding powers, and that whatever the subcommittee brings to the commission as a whole will be voted on by the commission as a whole. We had one meeting, and I'm not saying anything out of school because it was a public meeting, where we had a commissioner who announced on, I think, his first or second meeting that his purpose on the commission was to make it easier for consumer plaintiffs' attorneys to sue in class actions, and that he came to the commission with an objective. And I think it took a couple of meetings to let him know that that's not the intent of the position. And so it's always going to be dangerous if you have subcommittees of one. You don't know what's going to happen with a subcommittee of one. Furthermore, for all intents and purposes, we are already all subcommittees of one. I could go out and research any of these things on our agenda and come back to you and tell you, well, I've looked at this for hours and this is what I strongly think. So it's just sort of a tautology to call it a subcommittee of one. So not to be long-winded, but the bottom line is I think we could have subcommittees of two. We may want to research that a little bit more. I don't think there's an open meeting problem, and the subcommittees of two will just be in a purely advisory role.
Anna. Thank you.
Hi, everyone. From my end, regarding this particular topic, I would like to hold off until we know what is the work plan for the other issues as well. I just jumped in on this one because of my own historical and professional and personal interest in equal rights. So that was just my curiosity, but I'd be interested to see what is the work plan, not just for this issue, but the other ones that have been assigned to the commission.
Okay, that makes sense. Other thoughts, comments? Yeah, David?
Let me lower the hand first. A couple of reactions. One, Bagley exists for a very important public purpose, and I am reflexively uncomfortable with conversations about how to take us out of it. So I start from that proposition because it's there for a reason. Number two, I would query what we see the need is, because if we're going to address the question of removing part of our functionality from state law, I would want there to be a compelling reason to do that. So I'm not signaling a final view, I'm just suggesting a rubric for considering whether we really want to go in this direction.
And I'll jump in. I had exactly the same thoughts. That is, I'd be kind of uncomfortable trying to create subcommittees, structure them for the purpose of not having them subject to Bagley-Keene. That makes me kind of uncomfortable because even if we want to create a subcommittee of two, it strikes me that we ought to, if two was appropriate number for some purpose, we ought to have them comply with Bagley-Keene in the first place, because I'm uncomfortable about not having sort of public engagement in our deliberations and conversations. And the other thing I had on my notes that I always do for this thing is if subcommittees are the solution, what's the problem? Which I learned from GSPP at Berkeley. But so I certainly could imagine particularly complex or broad kinds of studies that it might make sense to chop up into pieces for subcommittees, but I'd want to have something that where the work, both maybe from a time standpoint and from a substantive standpoint, would be improved by having subcommittees work on it. So that's kind of my thought. Yeah, David, Korea.
Yeah, I think my takeaway from the discussion is that if we want, we have the flexibility to designate somebody either as a formal or informal or, in reality, subcommittee of one. And we kind of already do this. So it seems to me like we have been kind of doing this already, and now we know that that's okay. And the specific example I'm thinking of is some months ago this spring when Kristen was working on executive powers. And I took it upon myself to deploy some of my center's resources to do some research and provide Kristen with some information. So I think in that instance, you could say I was effectively acting as a subcommittee of one, not officially designated by the commission as such, but basically doing that. And that was okay at the time. And I think from this memo, I gather that even if the commission had taken a formal noticed vote to designate me as a subcommittee of one and send me on that mission to go figure that stuff out for Kristen, that would have been okay. So my takeaway is we have the flexibility to do this, and we can do it either in an informal way or in a formal way if we want to. So I think we're good.
Well, I don't disagree with the comment that we're good. I think there's a nuance between a commissioner doing research and a commissioner engaging with members of the public in conversation, if that conversation is not a public one in which others can engage. And that's my concern, that with subcommittees, there would be a subset of the commission engaging with certain members of the public on issues we are likely to vote on. And there is no visibility necessarily over what's being said and who's being selected for the one-on-one conversations with commissioners. That's my core concern.
Okay, Victor.
I kind of have the opposite concern. We had a discussion once, you'll remember, Brian, where it may have been in connection with the mediation confidentiality study, where there was some vague admonishment at the beginning. Let's make sure commissioners don't talk to the public about this because we don't want anything to look like it was not transparent. And my retort to that was, we were specifically appointed by the governor because we are members of our communities, both in our legal communities, our ethnic communities, our social communities, and so forth. So we do, by definition, represent an interface with the public. That's why there's a commission. My network is vastly different from the network of all the other commissioners, and I bring to that my conversations. And yes, I did have conversations with practitioners about whether or not mediation confidentiality would be beneficial or not beneficial. And I heard, I think, from equal numbers of people from both sides. That's part of why we're here, to talk to the public, and there's nothing untoward about talking to the public. I would be worried if we did it, because we're not monastic scholars who can just set forth on these topics. So I like talking to the public. I think we should, as individual commissioners. I have no qualms about us being formally designated two people as a subcommittee talking to the public, as long as those findings of that subcommittee are totally advisory and are subject only to discussion by the larger commission. No action will ever come out of the two-person subcommittees. So I'm not here to pick a fight. I'm just pointing out the obvious proposition that interfacing with the public seems to me to be a very important part of being commissioner.
David Carrillo.
It seems to me like it's a little counterintuitive. If Victor goes and does what he did, or I go and do what I did in the executive powers context on our own with no commission blessing, that's okay. But if the commission votes to make us a subcommittee of one to go and do that work, that then becomes a problem from Bagley-Keene perspectives, as Commissioner Huebner was describing. That seems to me to be the wrong answer. I think in general, it's part of the mission, and it should be okay for commissioners to go out and develop information, as long as they're not acting, on behalf of the commission or making commitments or, becoming a reverse avatar and advocating, for those people as their representative. If it's okay for me to gather information on my individual writ, even though I'm a member of the commission, it should be okay for the commission to send me out to do that, to gather information and to report back, as long as I don't bind the commission. So again, I think we're good. We might be arguing over semantics. So if people are concerned about it, why don't we just bag this whole subcommittee idea and keep doing what we've been doing, which is effectively the same thing anyway.
Anna?
Yeah, so concurring with that, I think that it really depends on what is the work plan for the commission. There are some issues that are high profile, and to protect the commission, to protect the individual commissioners, you want to have the official an official subcommittee. But what I would ask is that we table this issue until we know what is the work plan for the commission. And that way we figure out what issues merit subcommittees or not. That would be my recommendation for today.
That kind of makes sense to me. Any other questions, comments, suggestions?
Commissioner McAllister.
Oh, there you go. Okay, yeah.
I would agree with tabling it. I think the thing is that if it is a formal subcommittee, then there are lots of other attendant issues, like should there be minutes? Should there be, what kind of documentation needs to happen with the subcommittee? So, I mean, we don't need to discuss that here. I mean, when it comes back up, we can discuss it, but I think that those are other parameters that need to be defined and explored if that's something that we're going to approach and utilize. So that was just my thought.
Okay.
We done with that?
No other hands. So we will leave this issue open and come back to it at an appropriate time if there appears to be a need based on our work plan and goals and objectives.
That sounds reasonable.
Okay. All right. Next item is legislative program, Brian?
This is information only. There's no decisions that have to be made. And the information is all good. The two of the memos, bills, two of the bills have been chaptered already. The bill on estate planning and the bill to the technical cleanup of CPRA cross references, which was part of the maintenance of the codes bill. Those have been chaptered. I'm gonna have to look hard at the maintenance of the codes bill at the end of the session to see whether any of our provisions got knocked out and have to be reintroduced next year, but we were expecting that. The hazardous materials bills, I believe they got off of the suspense file. So they're moving again. That's a good sign. I think they're on third reading on the floor. Maybe I'm wrong. The other thing I report on is the three proposals that would assign the commission new work. And all three of those are on third reading on the floor. So if it's imminent and looks likely that they'll all be enacted.
Got it. Okay. Any comments or questions? Hearing none, seeing none. Okay. Item 5, emergency related reforms. Kristen.
Morning, commissioners. Can everybody hear me okay?
Yep.
Okay, great. So today before the commission, there are two memos. The main memo is relatively brief, and the supplement is actually where it's quite lengthy. There's a lot of details in there, and my presentation is not really going to go through all of those details, but sort of focus on some of the bigger takeaways and things for the commission to think about, offer their thoughts on, etc. There are no decision points for the commissioners today. These are kind of informational. We're still building content that we are going to be putting together in an informational report. So starting first with the main memo, there is a brief note about stakeholder outreach at the end, but the other two items that are discussed in that main memo relate to issues that were brought up at the last meeting that we wanted to address. The first of those is the character of different emergency rules as either mandatory or discretionary. And sort of the main takeaway for that is, for the most part, the mandatory rules in emergency law are process and timeline related. There aren't a lot of sort of substantive requirements about what needs to be done. And that seems to make sense because you just don't know what the emergency is going to require. The second, it involves different approaches to avoiding misuse of emergency powers. And that actually kind of flows throughout this study. One of the things that emergency law does is shift a lot of power and places it in the hands of the governor. And consolidating the power for an emergency is useful because when you have one person who's responsible for acting, they can act more quickly. When timeliness is critical, there's a lot of urgent things that need to be dealt with, and having one decision maker, you can move more quickly. Some of the process requirements are kind of cut away, so things can happen fast, and they need to in an emergency. So we see like there's a lot of trade-offs in terms of whether or not you want to move quickly or you want to add more process. And those things you can see in the discussion in the supplement is, in some cases they've placed more procedural requirements. You might have delays in those situations, but how you balance that in an emergency, I think, is one of the big fundamental questions to sort of grapple with here. The other thing to just acknowledge about avoiding misuse of emergency powers is there's really two ways that you can do it. You can sort of identify up front what you're not allowed to do, or place limits on like how long a certain act can go on. So you can, try to narrow things initially, or you can have responsive oversight where after something happens, there's someone who's charged with coming in and either saying, hey, no, that needs to stop. We don't think that's okay. For the most part, emergency law is kind of a mix of those two things, but I think you do see more sort of responsive oversight in emergency law just to avoid slowing down those initial emergency acts. So that, I think, covers that initial memo. I don't know if there's any questions or thoughts that the commissioners want to offer.
Any questions or comments? Seeing none?
Okay.
Good.
And so the supplement is quite lengthy, and it focuses on sort of the next phase of emergency law. So previously we talked about how do you commence an emergency, and once the emergency is declared, this supplement talks about what powers does the emergency law confer on the governor. So I just want to note this does not include fiscal powers. That was an issue that came up previously. That is something that we plan on looking at going forward. This does not address other statutory laws that might be located elsewhere that just activate an emergency. And that's a way the legislature can sort of decide up front some rule that needs to be in place in emergencies and, proactively adopt those rules as a way to make sure that, they have more involvement with what the emergency law regime looks like. So stepping back a little, as I mentioned, I'm not going to be walking through all the different examples that were provided in the memo. I do want to note, one of the things that the staff noticed as we were going through is putting together the policy analysis for the different approaches is it really does a lot of times break down into this idea of process versus speed. Process, information disclosure, some of the transparency things might be a trade-off for how quickly you can move. That trade-off is maybe minor in some situations because the process requirements may not require much, but still, we wanted to acknowledge that I think the policy analysis maybe starts feeling a little bit repetitive, and you start seeing the same things showing up as trade-offs in different places. So given that, we'll probably continue that as we present the material initially, but we're rethinking how that might look for the informational report and whether or not that same policy analysis will be included there. One of perhaps the different axes that the informational report could focus on is trying to identify where we're least comfortable, I think, with this idea of consolidated power. So that's one of the things that I was going to focus on is there's a lot of emergency laws include a power for the governor to either waive or suspend laws. And those powers are often limited or there are special rules that apply. And I think the feeling that I got from that is the reason is that the legislature is really concerned about when the governor is deciding to waive or suspend laws that were duly enacted. And for that reason, you see in those cases that states are perhaps more prescriptive with the situations in which the governor can take those actions. Or there is, a special limitation that maybe applies only to those types of acts that says they can only remain in place for a certain number of days, or they will later have to be renewed. You also see situations where there's a limitation where the governor is only supposed to make the minimum deviation sort of necessary to respond to the emergency. These types of requirements maybe help focus on limiting the exercise of powers that might be most concerning, where you might see the highest potential for, misuse, or just situations where you really want there to be more of an oversight and balance of power between different branches. So thinking about which areas where maybe emergency law might, need more attention, you could consider whether there are specific types of powers that you'd be most concerned with. One of the things I think in COVID you start to see is there is maybe more of a concern for longer term emergencies, things that have, broader statewide effects. Thinking about where the possible situations that you would need additional oversight and being able to sort of focus that oversight and those requirements on those situations instead of making broad changes to emergency powers on the whole. That may be something for the commission to keep in mind, whether we can identify those classes, whether we want to focus in more narrowly on something like public health emergencies, which is some states have laws specifically for public health emergencies. The draft model act, which is discussed in the memo, that's an effort of the Uniform Law Commission. They're working on, it's a model act. I hope I don't know if I mentioned it was model. But focusing on what powers might be needed specifically for those types of emergencies and what sort of limitations you want to put in place or restrictions you want to put in place for those types of emergencies. So another thing to consider, I think one of the things that often came up as I was working through this is I was sort of thinking about this as a trade-off between the governor and the legislature. And often the legislature is sort of sitting in an oversight role. A number of states have different structures in place where you don't necessarily report to the legislature as a whole. There's a committee of the legislature that might be charged with kind of doing the more direct oversight. So you're reporting to that committee and that committee decides whether or not it needs to be elevated. So there's also some structural questions about, could we move back to a regime that looks a little bit more like the normal balance of power between the legislature and the governor, but maybe also still recognizes that, the governor may need more powers than typical, but, perhaps less than the governor needed in the acute phase of the emergency. So I'm going to pause there and just see if the commissioners have any questions, thoughts. And I see Commissioner Carrillo raising his hand. And so,
David?
Thank you. I wanted to ask first kind of a process question. Again, in the interest of full disclosure, not hiding the ball, reminding everybody that a couple of the folks who work with me at the California Constitution Center have interacted with Kristen, provided her with some research that they've conducted and just generally talked with her about this issue. So my question to Kristen is, I hope they were helpful. And is there anything else that you feel like I can task my colleagues with doing for you as you move through your study?
So I will continue to talk with them. It's been a bit since I've talked to them last, but I do think some of the things that I'll be looking at going forward are areas that I'm less familiar with. So the fiscal stuff starts touching on budgetary issues and things that I've haven't had much experience with. I've also found sort of less information out there that really summarizes how some of that works across different states.
Mhm.
So I need to get my head around, I think, what the next steps are and what resources are out there and where I could really use some additional information. So I will do that. And
Okay.
keep that in mind.
Unfortunately, I think that the fiscal stuff is where my people can be less helpful. Like when I want to talk about the budget, I usually call Rick. So you might consider that doing that as well.
I might need to do that.
And so just, you know, I guess what I'd say is the part of this issue that I think my center's resources can be most helpful to you on is the high level separation of powers issues, which you mostly just summarized. That's primarily where we focused our research and analysis.
Well, and I do think, I mean, another area that I kind of touch on and just say we're setting aside for now is some of the questions about constitutional rights and the jurisprudence that's developed, I think, mostly during COVID around how do we think of emergency acts and those rights. And I think some of that is still evolving.
Yeah.
So, and it's been a struggle for me, I think, to figure out what to think about, you know. But the memo notes that I think firearms and religion are actually two very common topics where the emergency laws limit the governor's powers specifically related to those issues. And in fact, that's been an area that has gotten more attention, that religion in particular.
It's been litigated, yeah.
It's been litigated, and there's been legislative efforts, some maybe successful, but trying to figure out how those line up with actually what the scope of the constitutional rights is, I think is still kind of a moving target, honestly.
We've done some work on this. So if that's an area where you feel like the center could be helpful, we're, you know, again, more than happy to weigh in as, I guess what I should be calling it, as an ad hoc subcommittee of one that's not authorized by the commission. I'm going completely maverick here. But, you know, so it's just a long way of saying, you know, like, I'm just checking in. I hope my people have been helpful. I'm still interested in this issue. I have several people who are affiliated with my center who I know are still interested in this issue. So we're happy to continue providing resources to you in this unofficial, informal way if you think that would be helpful.
Yeah. And yeah, I'll keep that in mind and continue to think about it. I do think that, you know, the constitutional issues are ones that I've sort of skirted around because I've really been focusing pretty narrowly on the emergency statutes. So
yeah, we're all over the constitutional stuff. So when you get there, we'll jump on it.
Yeah.
Sounds good.
That's something Kristen and I have been saying we need to eventually do.
I will be there for you.
Done her tour of the statutory law and the other jurisdictions, and especially the separation of powers stuff. I presume that that's governed by California's constitution.
Yes.
Yes.
And so that would seem like a topic that's entirely in your wheelhouse.
We have a ton of research on that. Yeah.
But then the other thing, aside from separation of powers, the other thing that I think we need to get our hands around is the ways in which constitutional rights constrain governmental emergency response.
We've done work on that, and then overlapping both that and the first issue you mentioned is legislative delegation. You know, so can the legislature delegate power to the governor to do things that the legislature couldn't do itself directly, as by limiting constitutional rights? So they're kind of all part of a triangle. They all intersect and overlap. And so that intersection of those three things is primarily where our research analysis has focused.
Yeah, and we just haven't even started the analysis yet on the constitutional piece. And so
I can help.
Yeah, if you can like refer us to papers you've written,
sure,
or any of your colleagues or experts you respect on those issues. And like I said, it's not just about delegation and separation of powers. I think that's important. But it's also like, what are the boundaries of permissible state action?
Right. Yeah. I'll put together a list of resources, and I'll give you Kristen's already been in contact with a couple of people. There's a third or maybe a fourth person that I think I'm going to want to refer Kristen to for additional perspectives. So I'll put together some resources for you.
That would be really helpful. Thank you.
So, Kristen, I'm happy to try to be a resource, particularly on the fiscal stuff, if you like. And I will tell you, this whole conversation is giving me deja vu shivers, because there is a provision in the California Constitution in Article 4, Section 10 about fiscal emergencies. And that's one of the half a dozen pieces of the Constitution that I wrote. Back when Arnold was governor, we were dealing with sort of the fiscal crisis when he came into office and early in his term, and we were negotiating constitutional, both bond measure and constitutional provisions. And Arnold's proposal was to allow the governor to declare a fiscal emergency based on some general criteria. And the governor's proposal said, and part of the governor's responsibility was to send proposed legislation to the legislature. And the governor's proposal originally said, and if the legislature doesn't pass the governor's proposed legislation within 45 days, the governor can make any budgetary reductions he or she chooses. I mean, left sole power to the governor unless the legislature passed his fix-it statute. That would have obviously been a huge power shift from the legislature to the governor over the state's fiscal affairs. We objected. I negotiated and wrote what ended up in subdivision F, which basically said governor can propose legislation. Governor has 45 days to pass some bill or bills. And if they don't do that in 45 days, they can't act in any other legislative matters until they do pass something to address the emergency. So the trade-off that you were talking about, Kristen, about separation of powers between the branches, how big, how little, what the level of power shift is a big deal. And I do expect those trade-offs between efficiency and effectiveness and speed and public notice and stuff are all going to be real issues, and particularly some of the power shift and on fiscal issues in particular.
Yeah, no, thank you. I definitely appreciate it. And I do plan on drawing on some resources regarding the fiscal matters, because I'm not very familiar with that, as I mentioned.
David Hubner.
Kristen, first, thank you for all the effort. Wonderful briefing papers. Well done.
Thank you.
My comment is, I tend to be focused on how structures operate. There's unlikely to be extensive or even much analysis out there, but for my purposes, it would be helpful to also see not just the different structures, but whether or not the different legal structures have produced certain kinds of results, be they positive or negative.
Yeah, that actually is a really interesting question. I mean, I have not come across resources that really kind of evaluate how sort of effective different emergency regimes are in terms of how they structure, the legislative oversight. Although I'm seeing David Carrillo's hand. Is that on this topic? Okay, yeah. So it may be that those resources are out there and I just need to find them.
Can I weigh in? The short answer is, obviously you'd have to look at 49 other states, potentially, a number of other large democracies like England, Canada is another common example here. So, rather than doing a mega analysis of, 50 or 60 different jurisdictions, we did some point cases and wound up being glad that we didn't do a massive analysis, because we concluded that it's largely subjective in terms of the quality of the results that you get. So Commissioner Hemmer, you might think that it is a high quality result to have strong legislative oversight and to have short time limits and a big emergency break for emergency declarations, or you might make the qualitative subjective judgment that very long and very liberal emergency declarations by governors are better. So ultimately it comes down to a policy decision. So in the analysis, in the examples that we looked at, we found pretty high variety. You know, Canada, for example, has a pretty tight rein on emergency declarations. California is on the opposite end of the spectrum. And so it partly depends on, you know, what your subjective values are in designing the system. And that then leads to your subjective view of the outcomes. You know, I think this is a good outcome because I favor this kind of system, or I think this is a bad outcome because I favor this other kind of system. So we found those kind of questions to be largely subjective, and it ultimately all reverts back to what kind of system do we want to have in California?
Yeah, and I would say that what kind of system we want to have in California is also inherently subjective. There is no objective or subjective line here. What I'm saying is I would like staff to be aware that if there is information about analysis of the results of regimes, that will be useful for the commission to see.
Yeah.
Recognizing that the entire project is subjective. And as an example, if a particular regime on health-related emergency powers resulted in a COVID death rate 4 times the national average, that might be interesting to see. And I'm not saying it's out there, I'm just saying I'd like staff to keep their eyes open in case they encounter that kind of data.
Absolutely. And Commissioner Carrillo, if you could forward me that resource, that would be a great help. And I will keep my eyes open for such resources. So far, most of the material that I've found really is more descriptive about the laws themselves, as opposed to analytical about the results that we saw in COVID.
Yeah, and we've
Thank you.
also been focusing on statutory law. I wonder if it might make sense to reach out to people involved in public policy schools and see if you could figure out how to search their literature, because my sense of what Commissioner Huebner's asking about is more about practical outcomes under different operational regimes, rather than sort of governance outcomes, which I think is what Commissioner Carrillo was talking about. Like,
Well, we looked at both. So,
okay, good.
you know, so there were several different categories. So there's states like California that let the governor have a very long emergency declaration. The other end of the spectrum was a place like Florida, for example, which I don't think ever declared an emergency. And the data there is quite muddled. You know, even accounting for population size differences, Florida's COVID outcomes were largely the same as California's. So it was pretty difficult to draw conclusions from that. There were other states where the legislature either ended the emergency declaration by force or changed the underlying law to prevent governors from declaring emergencies. And not only were the populations so different that it made comparisons difficult, because you know, California is the largest state at almost 40 million people, so you pretty quickly run out of comparable population size examples. And even accounting for that, the policy variances were so great that we found it was very difficult to draw any practical conclusions from. If you have a long emergency, you get less COVID, or if you have a short emergency, you get more COVID. It really didn't support those kind of binary black and white conclusions. It was much more muddled than that. So it's worth looking at, but I didn't feel like we could draw any strong conclusions from that review.
Yeah, we could talk more about that later, Kristen. I'm just thinking not just COVID, because I think COVID is so politicized that the information environment is hard to parse. But I'm thinking like maybe there's articles about like wildfire response or something, like different approaches taken in different states. How did they fare? If literature like that exists, then maybe it would shed some light on like lessons. If you know, the lessons learned are, wow, we really wish we had the authority to do this, but we didn't, and that was a problem, then that might shed some light. So I guess the distillation is that I endorse Commissioner Huebner's idea about trying to see if we can find information about outcomes under different systems. I'm not sure we will, but I think it's worth looking.
Worth it. Yeah, worth looking to. Anything more from you, Kristen?
I think the one thing that I will note that I just wanted to draw the commission's attention to in the memo is different states take different approaches with respect to whether the legislature has an opportunity or is required to weigh in on individual emergency orders at some point. So that's something I think to keep in mind. California does not empower the legislature to either terminate, limit. There's no renewal for individual emergency orders. There are examples of states that offer those types of different powers. They may be limited to a certain set of orders. So like I mentioned, the waiver of statutory requirements, perhaps that's really the only set that the legislature is empowered to respond to individually. But whether you want the legislature to have a more individual power to actually respond to single acts, as opposed to, I think California's system is the legislature can turn off the emergency, but otherwise can't get involved with the individual acts of the governor. That's according to the statute. There's no
Okay.
express authority there. So I think that there's a lot of different things in the memo. I'm happy to discuss any of the details that are presented in there, or anything else the commission wants to talk about. But I don't want to just walk through that material again. And I think I've highlighted a few of the key points and some of the interesting stuff that kind of got spread throughout.
Right.
So.
Okay. Any other commissioners want to weigh in? Should we see if any of I know there's 8 attendees watching. Should we see if there's any public, any of the attendees want to make comments on this topic? Seeing none. Okay. Thank you, Kristen. Excellent job. I'm looking forward to more insight.
All right. Thank you, commissioners.
Okay, item 6, trial court restructuring. Brian.
Yeah, on this one, I would like to ask whether there's anyone in the audience who is attending for this item. Because if not, then maybe we move it to the end of the agenda so that we can address the topics where people have taken time out of their schedules to be here.
Good
So
idea.
anybody here on this item want to raise their hand? No, then
No,
in
Can we
fact, I
move-
think we lost somebody.
scared him off.
Yeah, trial court restructuring. You don't want to listen to that.
Yeah.
Then I would suggest we move along to the next item.
To Fish and Game?
Yeah.
All right, Steve.
All right, good morning, everyone. As at past meetings, you have again before you a reference memorandum, which is 2239. That requires no decisions. It's just a cumulative draft containing what will eventually be the proposed legislation for a final recommendation in the study. And then you have 2 other memos at this meeting, memorandum 2238 and its first supplement, both of which present staff recommendations to either add or not add to that growing proposed legislation draft. And as at previous meetings, pursuant to a methodology the commission has been okay with and has approved, the staff has proposed that after an opportunity for commissioners or any invitees or attendees to question or comment on any staff recommendation, that the commission consider all the staff recommendations in both of the memoranda, the memorandum and its first supplement, as basically part of a consent calendar with a single vote, hopefully approving all the staff recommendations in both memoranda. So, unless the commission has a problem with continuing with that methodology, are there any questions or comments about any of the staff recommendations?
Nobody wants to go fishing? Okay. Any?
And how
And this,
about-
and we're looking for comments or questions on either 38 or 38 for a supplement. Right?
Correct. I
Okay.
mean, if someone has a question about the cumulative draft, I mean, I'm happy to answer that, but there's no decisions that are required there.
I don't see any hands. Any fishing poles or gaffs or spears? What about attendees? Any of the audience want to make comments? Hearing none? Seeing none?
All right,
Everyone
well, in
agrees?
that case, I have a motion.
Is there a motion to approve the both memo
So
38 and
so
38
moved.
supplement?
So moved.
Been moved. Is there a second?
A second.
Second by Kara. Okay, Steve, call the roll.
Excellent, thank you very much. Commissioner Carrillo. That looks like an aye. Commissioner Kubas. I didn't, oh, you're muted.
Or absent.
Or
Or
something.
Not-
Come back.
Okay, maybe we'll come back there.
You may come
Commissioner
back.
Eater,
Aye.
Commissioner Jenkins,
Aye.
Commissioner King,
Aye.
Commissioner McAllister,
Aye.
Commissioner Simpson.
Aye.
Uh,
Are
I
approved.
don't know what you want to do here. Abstention, I don't know.
It would be not voting, I think.
Not voting.
Okay,
Okay. That then completes item 7. Thank you, Steve, as always.
okay, no problem. Thank